It wasn't until June that Europe breathed a sigh of relief after the European Commission adopted the adequacy decision for the United Kingdom. Now, the British government is planning a more independent data protection policy, which is to break away from the requirements of the GDPR. This could jeopardize the UK's status as a safe third country. Last week, the UK Digital Minister Oliver Dowden presented the main goals of the planned reform of UK data protection policy. The aim is to strive for a high level of data protection in a growth and innovation friendly environment. In particular, the aim is to develop global partnerships quickly and creatively, which make it easier for British companies to exchange data with key international markets. A new data protection officer is to be entrusted with monitoring the planned changeover. The British government last week named New Zealand's data protection officer John Edwards as their preferred candidate for the office. The term of office of the current data protection officer, Elizabeth Denham, ends after a 3-month extension on October 31st. According to the UK Digital Secretary, the new data protection officer, as the head of the UK supervisory authority in charge of enforcing data protection law, will go beyond the traditional role of the supervisory authority, which is solely focused on protecting data rights, and take a balanced approach which promotes further innovations and economic growth. I don't know if I really think that's a good thing. The UK government is also planning to remove unnecessary cookie banners. In principle, users should still have to actively consent if there is a high risk to privacy. However, the government does not consider many of the consent to be useful. In particular, there should no longer be queries about a large number of individual cookies in the future. Oliver Dowden explains it like this: "Now that we have left the EU, I am determined to seize the opportunity and develop a world-leading data policy that will bring a Brexit dividend to individuals and businesses across the UK." From my point of view, it's more businesses, by the way. That means we need to reform our data laws to be based on common sense, not ticking boxes. Well, the idea is not new. Alternatives to cookie banner solutions are now widely discussed. It was only in June that the NGO NIOP, together with the Sustainable Computing Labs of the Vienna University of Economics and Business, published a proposal for an automatic browser signal that could replace cookie banners. It remains to be seen whether a corresponding regulation is actually able to adequately protect personal data in the end. Furthermore, the global markets are to be opened up for British companies, and partnerships are to be concluded with countries that have high data protection standards. The aim should be that companies do not have to take costly measures to comply with the regulations in order to be able to exchange personal data with international markets. The partnership will build on the existing adequacy agreements that the UK has with countries around the world. In addition to the USA, this also includes countries as South Korea, India, Brazil, and Australia. The United States is one of the United Kingdom's main national trading partners in data transfers. In order to support action relationships and facilitate data transfers, obstacles should therefore be removed, but on the cost of the individuals, I'm quite sure. In the future, the British government would like to rely more than ever on other regulations, such as certifications, self-regulation codes, binding company rules, or standard contractual clauses. The European the Commission issued an adequacy decision for the United Kingdom on June 28th. After Brexit, the UK is now considered a safe third country for the next 4 years. At the time of the adoption, the European Data Protection Board had expressed concerns about the adequate level of data protection in the United Kingdom due to the national regulations on mass surveillance by police authorities and secret services. After the reform announcements by the British government, a spokesman for the EU Commission now expressly pointed out that the adequacy decision could be suspended or terminated before the 4-year period expired, and this could also be done immediately in the event of urgency. This would put many companies in a similarly unsatisfactory situation as with the current data transfer to the USA. And the plans of the UK are quite directed at the USA, and the USA does not have the standards the EU requires. So to trade data with them, for the companies, they are giving up their neighbor big market of a 450 million. Just think about that. I'll see you in my next video. Bis gleich.